I will be starting today's program with a quote by Theodore Roosevelt that goes thus: "No man is above the law, and no man is below it, nor do we ask any man's permission when we ask him to obey it." With this, I'll be welcoming you to another interesting edition of the Law Gallery, coming to you from the Lagos studios of KAFTAN Television. Khalid, Bada is my name. Recall that 2 weeks ago, in a 12-hour-long judgment, which at the moment is the longest duration of a judgment in the Nigerian history, President Bola Ahmed Tinubu's election in the February 25th presidential election was unanimously affirmed. Now, some of the issues addressed by the judges during the election petition was: 1, the allegation of the double nomination of the Vice President Kashim Shettima as a candidate, that it was a pre-election matter and it was to be discussed outside the petition, so it was dismissed. Another point that was made was the allegation that Tinubu isn't qualified to contest under Section 134 of the Nigerian Constitution. However, the ruled that he was qualified, and that was also dismissed. Now, finally, the most interesting one was the judgment about the status quo, the status of Abuja under the Section 134, subsection B of the 1999 Constitution, and that it should be read conjunctively. It was postulated that the section should be read conjunctively and that Abuja does not enjoy any special status under the Nigerian Constitution. Now we'll be discussing the legal and the constitutional perspective of this judgment as against the reaction of the Nigerian citizens. I'm sure that since the judgment, there has been a lot of opinions from Nigerians about the judgments made by the judges, especially the motion that Abuja does not enjoy any status beyond what every other nation, or whatever that state rather enjoys. Meanwhile, before we go into the discussion, you know I don't do it alone. I always have a legal practitioner, brilliant legal practitioners joining me in the discussion. Before we go into the discussion, let's join our newsroom for the relay of today's update. We'll be back.
Hello and thank you for joining us on the news update on the Law Gallery today. I am Esther Agbo. First on the list on our today's news says President Bola Tinubu on Thursday filed an urgent motion to stop Chicago State University, USA, from disclosing its academic records to People's Democratic Party presidential candidate Atiku Abubakar. Tinubu is seeking to delay the execution of the self-effectuating order directing CSU to comply with Atiku's subpoena until Monday. Newsmen report that Judge Jeffrey Gilbert of the United States District Court for the Northern District of Illinois on Tuesday ordered Tinubu's alma mater to provide all relevant non-privileged documents to the plaintiff Atiku within 2 days. The documents sought by the PDP candidates through his attorney, Angela Liu, include university admission and acceptance records, date of attendance including degrees, awards and honors that Tinubu obtained at the university, among other documents. The All Progressive Congress has rejected the PDP flag bearer's attempt to get the president's academic record, calling it a futile expedition. The ruling party said there was nothing to fear because the president always boasted that he had nothing to hide, but Atiku continuing to allege that Tinubu was ineligible to contest the February 2023 presidential election, obtained an order compiling the CSU to disclose the president's records. Atiku and his Labour Party counterpart Peter Obi challenged Tinubu's electoral victory in the Supreme Court following the Presidential Election Appeals Tribunal ruling that upheld the president's mandate on September 6th. Atiku had asked the U.S. court to seek an order compelling CSU to disclose Tinubu's academic records, raising questions about alleged deficiencies in the president's academic records. Tinubu's educational background shows that he graduated with a bachelor's degree in business administration, accounting and management from the CSU in 1979. but there have been allegations of discrepancies with his academic performance. But in justifying the president's decision to obtain the files, Atiku said unless clarification is given, it will be difficult for Nigerians to understand the educational background of the former Lagos governor. In response to an order by the court that he should make a formal filing on why his records should not be released, Tinubu claimed a clerical error was responsible for the discrepancies on the certificate issued to him by the university. According to filings by Tinubu's lawyer, Oluwole Afolabi, and Christopher Carmichael, an unidentified clerk of the university made the error about the date the school started on his recently issued certificate, thereby creating the appearance of differences. Regardless of his opposition to Atiku's application, Magistrate Gilbert ordered the CSU to release all relevant academic records of the president to his political adversary. But in a new twist on Thursday, the counsel to the former Lagos State Governor, Christopher Carmichael, filed an emergency motion titled Emergency Motion to delay dispositive ruling number 23CV5099, signed in the United States District Court for the Northern District of Illinois, Eastern Division. The motion read in part, Intervenor asks this court to enter an immediate order delaying the effect of the magistrate order, at least until Monday, September 25, 2023, so the court may fully consider both the scope of the magistrate's authority to issue the order without review and the issue of whether the magistrate order was a correct application of the law of the facts presented. In support of his motion, Tinubu said his request was based on the fact that applicant Atiku is challenging an election that occurred in Nigeria in February 2023. Application filed this case under 28 U.S.C. 1782 on August 2, 2023, after dismissing a similar Illinois State Court action that was originally filed in July 11, 2023. Tinubu's emergency motion was electronically filed with the clerk of the United States District Court for the Northern District of Illinois through the case management electronic case file. Moving on to the next, concerned about the increasing incidence of the unhealthy practices among the youth, the Delta State House of Assembly has called for the implementation of relevant laws to arrest and prosecute those involved in open sex trafficking and illegal drug use in the state. In a resolution passed at a plenary session chaired by Speaker Emomotomi Guwo, the House emphasized the need to condemn the open trade of sex and illegal drugs in all its forms. Their branching the resolution followed a motion by the member representing Oshimili South, Bridget Anyafulu, and was amended by the majority leader, Emeka Nwobi. The House in its resolution called on Governor Sheriff Oborovero to direct the Commissioner for Women, Community and Social Development as well as law enforcement agencies to take this opportunity to curb this ugly trend. Leading the proceedings, Anyafulu said the move had become urgent, noting that sex trade and illegal drug use, if left unchecked, would continue to pose a serious danger to the younger generation. Moving on to the next, Borno State Commissioner for Women Affairs and Social Development, Ajia Zuwaira Gambo, has said that only about 5,000 out of the over 100,000 repentant Boko Haram members were actual insurgents. Gambo made this known in Maiduguri while presenting a paper titled Borno Model at an event to commemorate the 2023 International Day of Peace, organized by an NGO Peace Ambassador for Humanitarian and Empowerment. She noted that those being de-radicalized and reintegrated back to their communities did not include the insurgents. She said that before the release of anyone and reintegration back to his community, such persons must undergo 3 weeks intensive training on human rights from security and religious leaders, and his community adequately contacted to endorse their return. The Commissioner solicited for support of the international community for the government to succeed in bringing lasting peace to the state. NAN reports that the Borno model is a non-kinetic approach aimed at handling counter-insurgency efforts and addressing humanitarian crises for over 1 decade. That's all on the news update today. Back to Khalid and Barrister Akinbuli for the interview. Bye for now. I remain Esther Agbo. The first public relations officer of the Nigeria Police Force, Olumoyiwa Adejobi, held a brief with journalists on securing of lives and properties across the country, which entails the introduction of digitalized Central Motor Registry (CMR) and revolutionizing vehicle registration in Nigeria.
Today, I am honored to present an overview of the transformation underway within the Nigerian Police Force Central Motor Registry (CMR). This transformation represents a crucial milestone in our commitment to safeguarding public safety and enhancing our capacity to combat motor vehicle associated crimes. Recall that in the past, our nation grappled with a surge in vehicle-related offenses, including car theft, snatching, kidnapping, carjacking, hit and run incidents, largely attributed to the use of unregistered vehicles, tinted windows, among other factors, which posed significant challenges across the country. This worrisome trend prompted a strategic response from the Nigerian Police Force, leading to the deployment of specialized border forces, tactical squads, force intelligence bureau personnel, and others aimed at curbing these criminal activities. In light of these efforts, the Nigerian Police Force rejigged the Central Motor Registry (CMR), a vital initiative that has played a pivotal role in addressing these challenges. The CMR has a rich history spanning over 6 decades, having been established in 1958 with a fundamental mission to combat vehicle-related crimes and bolster national security. As an invaluable repository of motor vehicle data and intelligence, the CMR has consistently, through limitedly, fulfilled its mandates by facilitating investigations, enhancing law enforcement operations, and ensuring the efficient recovery of stolen vehicles. However, recognizing the evolving technological landscape and the imperative of accessibility and efficiency, the Nigerian Police Force has embarked on a digitalization journey to further enhance the capacities of the CMR. This is very, very critical. Many groups are coming up under or disguising to be working for the police. I think any group, agent, company, partners, individuals, experts that have been given responsibility will be announced to all Nigerians by the Nigerian Police Force.
The Nigeria Police Force has stated that it is a vital initiative that is expected to play a pivotal role in addressing major problems.
The digitalization of the CMR represents a proactive approach to address these challenges, enhancing our commitment to citizen safety and security. The Nigerian Police Force has made substantial investments in a robust technology infrastructure, enabling real-time connectivity among all CMR units across Nigeria. There are a range of services provided by the Central Motor Registry CMR that cater for the diverse needs of our valued citizens, which include: 1. Motor vehicle information certificate. Obtain comprehensive information about a vehicle's ownership, history, and status to make informed decisions and ensure legal compliance. Change of ownership. facilitate a smooth transition of vehicle ownership with proper documentation. 9. Use imported vehicles and locally assembled vehicles. Register imported or locally assembled vehicles in accordance with regulations and safety standards. Issuance of tint permits. Apply for a tint permit to ensure compliance with regulations governing vehicle window tints. This has been a legal issue, tinted permits.
To enhance national security through CMR, the Nigerian Police Force appealed to all government agencies involved in the motor and vehicle administration system for cooperation and collaboration in data exchange and sharing. From KAFTAN TV, Esther Agbo reports from Lagos.
Welcome back to the program. It's still the Law Gallery coming to you from the Lagos studios of KAFTAN Television. And before we went on the break, I informed you that I will be joined by a brilliant legal practitioner who will be doing justice to our discussion about the legal and the constitutional perspectives to the judges of the election petition concluded recently. Now, today we are joined by a brilliant practitioner, Barrister Ebenezer Akinbuli. Thank you for joining us, sir.
Thank you for having me.
Thank you very much, sir. Now, let's just go into the discussion in proper without wasting much of our time. From your observation of the presidential election judgment and from the perspective of a legal practitioner, what sense do you make from the judgment? Just to let me push that to you first.
Yeah, thank you very much. As a legal practitioner that has been actively engaged with litigation, that knows the procedure for election petitions and that, I would say that this judgment that was passed is about the soundest that I've ever seen in recent times.
Could you come again?
Because the law court is not a Father Christmas. You cannot give what you do not have. You cannot give what was not asked of or asked for. So based on everything that was presented before the tribunal, based on the facts and the procedures and the rules guiding the election petition matters, this is the best judgment ever that one can say, okay, yes, from our electoral process and all. This to me is one of the best in recent times. That's my own view. I stand being corrected. We have people with, different opinions. That is why we are legal practitioners. But for me, that I'm into active litigation and procedures, I can say categorically that this is a very good judgment.
Thank you very much for that clarification. Now, why do you feel this is the best judgment ever made by an election petition? Is it based on the evidences that were presented, of which some were thrown out, or what particularly is your standpoint?
You know why I say it's a very good judgment is because of the fact that first of all, I salute the courage of our jurists. You know, if you look at the type of social cyberbullying that they got before the judgment was even passed. The judgment was even passed on social media before the judgment. So if you should look at the level of intimidation that they faced, and then the fact that they were still able to come out and call a spade a spade. You can't put something on nothing and expect it to stand. It cannot work. No matter how well you think you have won the election, if you didn't bring in your case properly and put it on a solid foundation, it will collapse. It's like building a house. How would I put it now? Putting a castle in just how will it stand? There's no proper foundation. You are a lawyer bringing in election petition. You know you are supposed to prove your case. You are alleging that there was malpractice in all the local government. You didn't even state one unit where this election malpractice was, where it occurred. You did not put one there. So is it the court now that will be going to be shopping for your evidence for you?
However,
It can't
there
happen.
were evidences that were gathered from the social media platforms that we saw cases of votes buying and violence during the election.
For social media evidence, what evidence was presented before the court? The court is not on social media. You can't say you are pasting evidence on social media when you didn't even place it before the court. It is what the court asks that the court will work on. You are supposed to bring in your evidence. I was saying, for instance, you are alleging that you have spreadsheets to confirm the results of the election that you won. You just said you are going to rely on the spreadsheet. You never brought the spreadsheet before the court to see. So what would the court do? The court will just, okay, you said there's a spreadsheet, so therefore, because of that spreadsheet that you said, you won the election. It's not done to my brother.
However,
so that's why I find it very, very funny when I hear lawyers claiming that there was injustice. I want to believe that the injustice itself was done by the petitioners or the people that filed the petition. That's the injustice that was done. Because there's no way you have a very good case if you didn't present it properly. Then, my brother, is as good as you don't have anything. In the words of Lord, he said you cannot put something on nothing and expect it to stand. It cannot work.
So, Barrister, INEC spent a lot of money into procuring the beavers, and according to research and according to what the INEC said, results are going to be processed through the beavers and the IREV. However, there are some constituencies where the results were not done. Meanwhile, the court made a point during the judgment that INEC isn't mandated to transmit results through IREV. Now, how are we supposed to balance that, even though they spent a lot of taxpayers' money into procuring this system? And how are we supposed to trust the transparency of the process then?
My brother, the court is the court. The law is the law. INEC is INEC. INEC is court independent. They are an independent body. So the law is the law. If the law says that I shall, then it is mandatory. If the law says, if the INEC says that I may, then it is at their own discretion. Now, the INEC rules says that INEC can make procedures on how to conduct the election. Now, one of the procedures that INEC did was to say, okay, we are going to introduce beavers. And the election was done with the use of beavers throughout Nigeria. Nobody complained about that. Because without the beavers, there is no way you would have been able to register to vote. Because everything is done electronically. Now, it is not the issue of upload to IREV. All of these things is just INEC's own way of making sure that the election is free and visible enough. However, it's not a must that if they don't upload it to the IREV, the election becomes popular. That's not the law.
But doesn't it
the law is that
doesn't it buttress the opinion of the petitioners that the election was not free and fair?
No, that's not even an issue. The petitioners themselves did not say that the election was not free and fair. They did not complain that the election was not free and fair. They said the failure of INEC, transmitting the presidential election, the result of the presidential election through the IREV, therefore they sense a foul play. Now, why was it that only the presidential election results were not uploaded to the IREV or on the IREV? And then INEC is that I am not, by law, I am not mandated to even upload it to the IREV. My own is to make sure that elections were conducted and there was a winner. The mode at which I want to arrive at all of these things is irrelevant. If I made the rules, state that this is what I want to do to achieve this. If I say I want to drive a car from Lagos to Ondo State, for instance, and I say I want to use a Land Cruiser so that I will not feel the hiccups on the road. Are you with me?
Yes.
And I purchased a Land Cruiser and all of that. And when I got to, and I started the journey, and I got to, what's it called? Redeem Camp.
Okay.
And I decided to just, let me opt for a Corolla.
Okay.
Let me just, let me park this my Land Cruiser and enter to Ondo. The fact that I'm able to get to Ondo is the result. How I'm able to get there is nobody's business. But assuming the law is clear that shall be uploaded to the IREV, failure to upload IREV would mean that it is. Then you can now begin to say, yes, because you did not upload to the IREV then, but there's nowhere in the law, there's nowhere in the act, INEC Act, that says, Electoral Act, that says that failure to upload result on IREV will render the election inconclusive. No way. Well, the lawyers ought to be tackling irregularities in polling units, bringing evidences that are voting in some areas. They did not. They were attacking certificate, attacking FCT, attacking what is not supposed to be attacked. So me, in my opinion, I see it as some lawyers who are in the academics just coming to want to lecture judges. I tell you that you can't lecture me. I work based on the rules before me. The rules, the evidences, the cases presented to me is what I'm going to work on. Anything outside that is relevant. So you cannot come and coax the judges, bully them, and make them look like what they are doing they don't know. It's wrong.
Now,
so the lawyers that are doing justice to the petitioners.
Right? There is this discussion about a constitutional crisis that occurred during the judgment. Now, this is based on the issue of Abuja being a state or not. Now, during the judgment, it was stated that the section 134 subsection B of the Nigerian Constitution should be read conjunctively, and that Abuja does not enjoy any special status. Now, one of the things that was raised was that a presidential candidate has to win at least 25% of all the votes cast in the Federal Capital Territory. Now, what is your opinion about this? What do you have to say to this?
Now, what the law says is that to win a presidential election, you must win 36 states, 25%, 36 states, and the FCT. Now, the reason why there is that "and" is because the FCT is there, is floating on its own.
Okay.
Are you with? The FCT is floating on its own. It does not have a special title or special acumen. It's just like any other state. If the Constitution provides for that the FCT shall be seen as any other state.
Okay.
So for the event of calculating a presidential election result, and Abuja becomes like any other state. It becomes like any other state. It does not have any special status. It's like any other state for the purpose of that presidential election result.
So that means just for the election result is when Abuja is treated like every other state, but on every other level it enjoys a different status.
The Constitution made it clear that Abuja, to me, is like any other state. But because of the fact that is where the president sits, you can't have a governor and a president. So the president performs the duty of the governor.
But
he performs the duty of the governor. It's in the Constitution.
Now, some groups have started raising advocacy that they want Abuja to own its own government. Don't you think the court should have foreseen something like this and maybe tried to avoid this situation? Because obviously it is creating a lot of questions are arising, and people are having a lot of opinion about this.
My friend, the people that are saying that Abuja should have their own government and all of that, perhaps they don't know anything about Abuja. I live in Abuja. Abuja has a government. There's the FCTA. We have the Federal Capital Territory Administration being run by the minister. We have local government chairmen. We have councillors. Abuja have House of Representative members. Abuja have senators. So Abuja have a government. It is only the status of the governor that is being run by the president. That is it. So Abuja special title or status.
Thank you very much for that clarification, Barrister Akinbuli. I think the issue of the Abuja status was one particular thing that was creating controversies and raising a lot of questions about the judgment. Now, the petitioners have said that they are going to go to the Supreme Court. What do you have to say to that?
Yeah, sure. It's a welcome idea. That's the tribunal is not the apex court. They have the right to appeal. So I'm in support of them going to the appeal court. I mean, to the appellate court. That's the Supreme Court in this instance. So instead of, that's what I expect them. Instead of going and crying foul on social media, you go and test the law. Go back to go to the Supreme Court. And let the Supreme Court see the error that you are seeing. Make them see the that you are seeing, rather than going to social media and one is refuting the legal profession, calling our judges names and all of that. That's what I stand against. I totally stand against all of it. You don't come to a court with a bad case and then the court decided on your bad case, and then you are now going around to say the judges are corrupt. Even in your grounds of appeal, one of the things you will say is that the learned trial judges, they erred in law. Anybody can commit errors.
Okay.
So you don't just come and begin to say anything. You can commit errors and all of that, and you have to appeal. So I welcome their right to go to the Supreme Court. It's welcome.
Thank you very much for that opinion, Barrister Akinbuli, and that is where we'll be wrapping up the interview segment for today.
Thank you very much.
I really appreciate your time. There you have it, there, viewers. The niche of the whole discussion is that we should trust the Nigerian Constitution and we should trust our legal practitioners. Now, Barrister Akinbuli, he established the fact that the judges know what they are doing. We, the citizens, have our opinion, we have our interests, but we should understand the fact that the court doesn't see the interest of the people. The court only sees the evidence that has been presented before it, and it judges based on the discussion, based on the evidences that has been presented before it. Now, it's a good thing the petitioners are allowed to go and appeal at the Supreme Court, and we'll keep you updated on what is to come from that. And with this, I'll be wrapping up the program for this week. To come back, same time, same station. I remain Khalid. Bada. Bye for now.